Robert, great to have you on the program.
My pleasure to be here.
Another big win for firearms preemption. I'm sure you're very happy about it. But this time an appeals panel strikes down a ban on what Nassau County wanted to call deceptively colored guns. I got to ask you, considering how anti-gun New York is, were you surprised by this decision?
I actually wasn't, Ginny, only because of the strength of the argument. New York has, in state law, an extremely detailed and comprehensive regulatory scheme for handguns. It goes all the way back to the Sullivan Law 100 years ago. And because of how intricate and detailed the handgun licensing system is in New York, it does not leave any room for localities to regulate handguns, and that's exactly what the appellate court unanimously held. And
it is so true. I mean, those four judges who handed down this decision, they made it clear. Preemption means what it says. They didn't buy the county's arguments at all.
That's absolutely right. It was an uncharacteristically long opinion for this court that typically issues, in most decisions, a paragraph or two. It's a 12-page opinion that very methodically goes through and discusses preemption, and it compares it to, for example, the state's alcohol and beverage control law, which is a very intricate. If anyone has ever had to apply for a liquor license in New York, they know it's an extremely arduous and difficult process. There's extensive regulation, and the state, we compared that in our brief to the firearm law to the alcohol and beverage control law, and the court seized on that and said, you're right, just like the state can preempt the field of liquor licensing, it also preempts the field of handgun licensing because this extensive network of laws is already in place.
Yeah, and originally under the law, if your gun was black, gray, silver, or army green, you were fine. If it wasn't, it was banned. And then the county actually changed the law, didn't they?
That's right, and that was in direct response to the filing of the original suit. Once they saw that they had been sued and were forced to face the terms of the model legislation that they were fed by an anti-gun group, which banned all these colors, they immediately saw they were in jeopardy, and they hastily amended the law, but they didn't do enough.
No, because, here they did change it. They said such things like gold-plated or ivory handles, that was okay. But that didn't help Alan Schwick.
That's right.
Because his gun was pink.
That's right. He had a pink pistol, and he wasn't going to get rid of it.
Got to ask you, you have to know, Mayor Bloomberg is not happy about this.
No, he can't be, because New York City has a functionally equivalent law that also bans colored handguns, and they also do not have state permission to enact that law, so their law is vulnerable to be nullified by this exact same decision.
Now, will this only apply to New York? What about other states?
This is strictly limited to New York.
Okay. So what about the chances the county's going to appeal this?
It's a real possibility, only because under New York law, a constitutional provision, a decision on a constitutional provision has an automatic right of appeal, and in New York, preemption is a state constitutional issue. So it will be up to the Nassau County whether they appeal this to the State Court of Appeals.
But when you look at preemption, it's really been put to the test, and it's on a roll, because you look at what happened in Ohio with the Supreme Court upholding preemption.
It is, and preemption is a sort of a touchstone issue for gun rights activists, because it really prevents localities, counties, towns, cities from encroaching on the state legislators' prerogative to regulate firearms in a comprehensive manner.
All righty. Well, stay in touch and let us know what happens if they decide to move on an appeal.
I sure will. Thanks for having me on the show.
All right. Thank you so much.